Welcome everyone. Welcome back to True Crime Files with Kathy. The other day I did a recording on the Michigan woman who managed what I call the Mission Impossible. She escaped from a police car whilst in handcuffs, but the police car was locked, so she was locked inside. And apparently, the only reason why Kendra was arrested is for violating her parole. After escaping the police car, she was handcuffed, placed in the back of the police car, but then managed to squeeze through a partially open window and flee the scene. Kendra had an outstanding warrant for a parole violation. So, she's just made it really comical. And since I did my video of her on my YouTube channel, I've seen quite a few people actually do the same thing. It is so comical and that you wouldn't expect it. And, she's got balls, bless her, and the agility to be her body out of a small window. It's a good job she's not as big as me, because I definitely wouldn't fit through a small window. But I'll play this news, and if this one doesn't play the court hearing, I'll play the court hearing afterwards. Oops, might help if I go on one.
Shared hundreds of thousands of times across social media. A local man captured video of a woman climbing from the back of a Muskegon Heights police vehicle and running away in handcuffs.
2 days later, that woman is still not in custody, according to the Muskegon County prosecutor. 13 on your side's Micah Cho has details on the video and where the investigation stands.
It happened here at the Old Omni Fitness Club off of East Norton Avenue in Muskegon Heights at around 3:30 p.m. on Saturday. Now, according to dispatcher audio, Muskegon Heights police were called here for reports of a suspicious vehicle. Now, around 30 minutes after that initial phone call, that's when that viral video starts. We can see that woman kind of peek out of that.
She is so lucky. It could have gone so very wrong. She could have landed up falling head first and cracking her head open on the road there. But it is funny.
That Muskegon Heights vehicle, it took her about 10 seconds to get both of her legs out. You can see her run with her hands behind her back, and she starts heading down Peck Street that way.
Subject right northbound from the Omni.
Northbound from the Omni. Do you have a description?
White female, blonde hair, all black.
That video that was shot by the Block Paper Weekly ends there with that Muskegon Heights police cruiser going up Peck Street. However, around 3 hours later, just a few blocks away, around the 3000 block of Sanford Street.
Now, dispatch audio describes a suspect with the same description trying to break into a house with the key identifier. That person was wearing handcuffs.
Peony, Sanford, color watched on camera, female, white, female, black shirt with handcuffs on, going to the house. The female is going to be in the caller's basement. The caller is waiting outside of the house.
According to the Muskegon Heights Police Department, the suspect, who has not been publicly identified, has an outstanding parole warrant. For now, in Muskegon Heights, I'm Micah Cho for 13 on your side.
See, that is just so funny. But let's go on to the next bit afterwards. She's 38 years old as well, so she's doing well for a woman. I think that this one is the one I want. Oh gosh, why have I gone and done that just now? Bear with me. There we go. Now I can make the screen large.
All right, good afternoon. You are Kendra Aney. Is that the correct way to pronounce your name?
Yes.
All right, Ms. Aney is before the court on two separate files. They're both entitled People of the State of Michigan versus Kendra Lee Aney. File numbers are 26247 814 FY and 26247 852 FY. Mr. Matthew Roberts represents the state of Michigan on both matters. Ms. Sean Perry is appearing, I believe, on behalf of Ms. Aney in both matters.
That's correct, John.
And we are convened here for an arraignment on two felony complaints. In file 814 FY, the complaint alleges that Kendra Lee Aney on or about March 28, 2026, in the city of Muskegon Heights, Muskegon County, Michigan, who did in count one willfully and maliciously destroy or injure certain personal property, to wit, handcuffs belonging to or possessed by a Muskegon Heights Police Department. This is called malicious destruction of police or fire property. It's a felony. It's punishable by up to 4 years incarceration and or a $5,000 fine plus court costs and restitution. Count two alleges that the same defendant at the same time, date, and place did break or escape from lawful custody while under criminal process, to wit, climbing out a police cruiser window and running away. This is called escaping from lawful custody. This is a misdemeanor. It's punishable by up to 1 year in the county jail and or a $1,000 fine plus court costs. In file 852 FY, you are before the court for arraignment on a felony complaint. This complaint alleges that Kendra Aney, on or about March 28, 2026, in this city of Muskegon Heights, Muskegon County, Michigan, you did at that time and place, break, and enter or enter without permission a dwelling located at 3328 Sanford Street, and while entering in, present in, or exiting the dwelling, did commit the misdemeanor offense of escape from lawful custody. This is a felony called home invasion, third degree. It's punishable by up to 5 years incarceration and a $2,000 fine plus court costs. On both felony complaints, it's alleged that you are a fourth habitual offender. In file 814, it's alleged that on or about October 10, 2016, February 27, 2017, and September 13, 2010, you had previously been convicted of these three felonies, respectively, operating intoxicated third offense, delivery or manufacture of less than 50 grams of a major controlled substance, and attempted larceny in the building. Those felony convictions are alleged to have occurred in the 14th Circuit Court in Muskegon County and the 20th Circuit Court for Ottawa County. The complaint in 852 FY alleges that you were previously convicted of 3 or more felonies or attempts to commit felonies in that on or about January 13, 2017, August 28, 2016, and September 17, 2012. You were convicted of the following offenses, respectively: delivery or manufacture of a major controlled substance, operating intoxicated third offense, and larceny.
So basically, Kendra has a very colourful past. For a 38-year-old lady, she's done really good, isn't she? She's managed to do quite a few things, except for murder.
In the building. Those felony convictions are alleged to have occurred in the 14th Circuit Court in Muskegon County and the 20th Circuit Court in Ottawa County in the state of Michigan. Therefore, the underlying offenses of home invasion third degree and
Oops, we lost the sound there.
become subject to the Habitual Offender Act. Home invasion third degree and file 852 FY then becomes a felony punishable by up to life or any term of years in the discretion of the sentencing court. Malicious destruction of police or fire property in 814 FY then becomes a felony punishable by up to 15 years incarceration. That would be in the discretion of the sentencing court. You have the right to remain silent, and you say orally or in writing can be used against you in court. You have the right to have a lawyer present with you during any questioning which you might consent to. If you do not have the money to hire a lawyer, the local indigent criminal defense system will appoint a lawyer for you at public expense. You have the right to have a lawyer representing you at all court proceedings. You have the right to have a probable cause conference and a preliminary examination scheduled on both of these files and have those hearings set and heard in the next 21 days. You have the right to be considered for pretrial release and to a trial by jury. As to your right to counsel, you indicate on your request form that you have no income presently. Is that a true statement? Yes. Ms. Perry, then?
Yes, Your Honor, we'll accept the appointment.
All right. So the Public Defender's Office will be representing you on both these files. Right, in both files, we'll have the matter set for a probable cause conference and a preliminary examination. Your probable cause conference is scheduled for Wednesday, April 15, 2026 at 1:30 in the afternoon in this courtroom, or excuse me, on the second floor here in room 215, right across from courtroom 4 here. The preliminary examination is scheduled for the following Wednesday, April 22nd, 2026 at 9:30 in the morning in this courtroom, courtroom number 4. Ms. Perry, anything as to bond?
Thank you, Your Honor. Miss Amy is a resident of Muskegon County and has been for all of her life. She is suffering from drug addiction, Your Honor, and has suffered greatly as a result of that. What I'm going to ask the court is as follows. You set a reasonable bond, but that you give us the opportunity that if she can get into inpatient counseling during this time, that she be able to be released to the inpatient and then returned to jail unless she's able to post a bond.
Okay, thank you. Anything, Mr. Roberts, as to bond?
Yes, Your Honor. I think at the outset, I think it's fair to say that this is not a situation where the court should be looking at whether or not Ms. Aney is entitled to a reasonable bond, or excuse me, to a personal assured or personal recognizance bond. It's difficult to imagine a scenario where the need for an actual cash bond is more appropriate, even despite the circumstances here with the charges, than this case, to prevent Ms. Aney from performing another disappearing act that she tried to pull off on Saturday. I will say this, that in general, the court is well aware that our...
Did you see the way he looked at her? Let's go back just a tiny bit. Those eyes the judge gave her were evil.
An actual cash bond is more appropriate, even despite the circumstances here with the charges, than this case, to prevent Ms. Aney from performing another disappearing act that she tried to pull off on Saturday. I will say this, that in general, the court is well aware that our office's policy, and certainly my policy, is that whenever we're dealing with a person who is suffering from substance abuse issues, that generally release to inpatient treatment is something that we can go along with. Unfortunately, I would say that Ms. Aney, of any individual that we've come across, has forfeited her right to be granted.
Now, is he in deep thought thinking to himself, she's quite good at escaping from a locked police car through a window? Or is he thinking, should he take pity on her? I haven't seen this bit of news, and so that's why I thought, well, I'll do the first part and the second part. So it's really good to react to a video that I've not seen. So I'm reacting it at the same time as everyone else that's watching this. But his looks, when he looks at her, is like, what do I do with you? But to me, he'd be stupid to let her out on bond, even to get drug treatment, because she'll escape. You know, she'll go and hide in again, and that she's safe enough to go to jail and get the help that she needs in jail, because there'd be just as good programs in jail as there is on the outside. But I do like this judge's facial expressions, and the way he looks at her is classic.
That opportunity as much as she may need it, and I don't doubt that might in fact be the reason that she's committed these offenses and that she needs that, but she's just demonstrated through her pattern of behavior here that she cannot be trusted to do that. And if the actions of Saturday and the actions of the fact that she was already on parole and hadn't absconded warrant for parole at the time this took place, it showed us anything, is that we could not trust her even in an inpatient setting. So as much as it pains me to say that I don't think she should be entitled to that benefit at this point, I don't think she has earned that benefit at this point. As the court is well aware, inescapably it has three options to look at here, or three factors that it should look at here.
Don't they realize whispering is rude? And that I wonder what she's saying to her. We need some people that can do lip reading and that, but whispering is really rude, lady.
The court rule, there's a number of factors, but I think three really stand out to the court. Excuse me, in terms of setting bond here. And first is the person's likelihood to appear back in court, and obviously that is the primary purpose of bond. And again, there may not have been a defendant in the history of Muskegon County who has demonstrated that the order to appear or to follow procedures or to follow direction there might not be a defendant who has demonstrated a clearer disregard for that than Ms. Aney by her actions here. Again, she's on parole, she's on ensconced status from parole, and we have all now seen, I'm sure, video taken of her escaping from the Muskegon Heights police cruiser on Saturday. So she has clearly demonstrated that disregard for court orders is something that she is certainly prepared to do and would do. I think I have no question in my mind that she would do that under the circumstances here. I know the temptation would be that because she is on parole and she will likely have a parole hold, to rely on that parole hold, but I think we've all encountered situations where for whatever reason that does not stay in place, or there's some mix-up, or that gets lifted for some reason at some point down the road. So I don't think we rely simply on the fact that there's a parole hold here that will join her as well. I think that doesn't abrogate the court's responsibility here to set what I believe should be a high cash bond for this matter. The second factor that the court can look at here is the likelihood of conviction, and I've alluded to it already. We've all, I'm sure, in this courtroom seen the video of Ms. Aney escaping from the Muskegon Heights police cruiser. Certainly, that as it relates to the charge of escaping from lawful custody, the entire thing is captured on video, and the very fact that she was in the cruiser one moment, then gone the next, certainly demonstrates that she escaped from lawful custody without being released by the police officers who were involved in this situation. So the likelihood of conviction is there is very high. And as it relates to the charge of malicious destruction of the handcuffs in this case, while Ms. Aney was apparently able to Houdini her way out of the police cruiser or confined space, she had not yet demonstrated the ability to escape from handcuffs because at the time that she was ultimately picked up yesterday in the morning, she was still wearing the bracelets of the handcuffs. She had damaged them and destroyed them to have them separated, but now had worked her way out of the handcuffs. So those were still on her at the time that she was arrested yesterday. So I think the likelihood of conviction is high there as well. Finally, Judge, despite, and I recognize from the public's perspective and even from a court perspective and everyone's perspective, that there is an element to this that is amusing to some regard, and I don't want to ignore that. But what we cannot escape here is that
we are not amused. That's exactly what it looked like. It was like, well, I didn't find it amusing, but I think several million people on YouTube find it quite hilarious. I certainly found it hilarious.
There is also an element to this that was incredibly, incredibly dangerous. First of all, to herself, to even attempt this and to have been able to do it, I don't know how she did it, but to do it without injuring herself alone is significant. Most people, I think, under that situation would have simply fell out of that window and probably injured themselves very seriously, if not more, by landing on concrete, which is where this cruiser was parked at the time. But beyond that, and the factor that the court, I think, here can really look at the most is the seriousness of the offense, and that relates to the home invasion charge here. That for as much as people might want to support Ms. Aney or think that what she did here was somehow noble or good for her, that type of thing, the bottom line is in escaping from custody here, she broke into someone's house. Now, fortunately, nobody was hurt, nobody was home in that situation. But we've all seen situations where under these circumstances, and particularly people in Ms. Aney's suffering from the issues that Ms. Perry says that she has, and again, I don't doubt that those issues exist. We've all known situations where people, for whatever reason, break into another person's home and try to steal some property or try to escape from the police, and those turn out very, very badly. Unfortunately, that did not happen here, but it doesn't take away from the seriousness of the offense here, and that alone, I think, calls for a substantial cash bond here. So again, while under normal circumstances, I would probably agree to or even advocate for a person to be released to inpatient treatment to get treatment for their substance abuse issues, that is simply not a risk that the court, I think, would take at this point, because quite frankly, I think it would be a situation of now we see her and then we won't when it comes time for Ms. Aney to appear in court.
That's it. Get a nice close-up of that judge. Let's see his facial expressions.
Under Michigan Code Rule 6.106, subsection C, I start with the presumption that the defendant is entitled to a personal recognizance bond. Subsection C provides that if the defendant is not ordered to be held in custody pursuant to subrule B on the major capital offenses, murder or armed robbery or criminal sexual conduct first degree, the court must order the pretrial release of the defendant on a personal recognizance, unless the court determines that such release will not reasonably ensure the appearance of the defendant as required, etc., or will not present a danger to the public. Well, I'm finding that her risk of non-appearance and her present danger to the public outweighs and rebuts the presumption of a personal recognizance bond. Additionally, Michigan Court Rule 6.106 subsection F directs the court to consider a number of factors when I make the determination of bond. One of those factors is the defendant's prior criminal record. It's lengthy. It includes prior convictions for operating intoxicated second, escape from lawful custody, attempted larceny in the building, unlawfully driving away a motor vehicle, larceny in the building, operating intoxicated third offense.
The bond will be set really high, I should imagine, and she's not going to be out on like license or whatever they call it before the court trial, and that she's going to go down to jail, and her bond is going to be set unreasonably high, knowing she's got no way of income. She's probably nothing got anything to do with her family because of the drug habit, and no one's going to bail her out. But let's see, shall we?
And delivery or manufacture of a major controlled substance less than 50 grams. Her prior record alone rebut the presumption of a personal recognizance bond. Subsection F additionally directs the court to consider the defendant's history of substance abuse or addiction, and apparently it's significant. That weighs against the personal recognizance bond. The seriousness of the offense charged is one of the factors I'm to consider. And this is not amusing to the court in any way. It's sad, is what it is. It's a sad story. But it is a serious offense that happened here that can have serious consequences, some unintended. I'm also considering other factors that bear on the risk of non-appearance. Can that phone be removed from the courtroom, please? So I'm considering other factors that bear on the risk of non-appearance, and one of those factors that I read in the affidavit for warrantless arrest indicates to the court that the defendant, when arrested on the parole absconding warrant, gave a false name to the officer, required them to check fingerprints to really get her identity, so she was willing to fabricate her true identity to the officer, and then apparently when under arrest on the abscond warrant, was able to escape the interior of a police cruiser and flee on foot while in handcuffs. That demonstrates to me, like I said, a very sad situation regarding the lengths to which she's willing to go to maintain her substance abuse. And I've said this before,
And I'll say
but
it again.
these major substance abuse cases are not victimless crimes. Miss Amy has been robbed of her life because of the substance abuse. She's being robbed of her freedom.
Has this judge got a heart? Has he got, shown some sympathy for Kendra? And that you can never tell with him, can you? 1 minute he's quite stern, and next minute he's sounding as if he's concerned about her. But yeah, anyone that takes drugs for all their life are robbed of their life. You know, if they took drugs in childhood, they're robbed of their childhood. And it's the same in adulthood. And, you know, all those recovering addicts, I take my hat off to them because it's not easy to come off drugs. It's easy to get addicted to the drugs. And drugs can be even painkillers. My uncle once was addicted to taking cocodamol. He would take it 2 tablets every hour. And, you know, so it's still a drug and it's still an addiction. And addictions happen really, really quickly. But to come off that addiction, it's not as easy as it was going on it. So anyone that may be watching this video, if you've had similar experiences where you were addicted to a substance or a drug and you've managed to come clean and stay clean, even if it's alcohol, then I applaud you. You know, give you a clap. I really do applaud you because it is so hard. I can remember 25 years ago when I tried to give up smoking. It was the hardest thing I put myself through. I eventually did it, but then came along the flavored vapes. Admittedly, my ones are nicotine free, so you know it's just the flavor that I'm going for. I used to sort of like always have chewing gum in my mouth because I like the taste of the chewing gum, but now I've replaced that with vape, so it's still a form of addiction, you know. And it's so easy to get addicted to things without knowing or wanting to. And then to come off it, it's so very hard. So anyone that's managed to come off any alcohol issues, any drug issues, anything, I really do applaud you because it just shows you are stronger than you think. If you can overcome withdrawal symptoms and stay clean, it shows that you're a strong-willed person. And, you know, hopefully, you know, you'll have a good life and you can live your life. But anyway, I sidetracked right off this court case now, haven't I? But yeah, I just want to put that message out there because, you know, I feel it's really important, you know, that anyone on drug addictions that's come off it and stay clean, it's really hard work for them and well done to them. I really mean that from the bottom of my heart. You know, well done to them.
Anybody who comes into this court and says that controlled substance offenses are victimless, talk to Miss Amy about her life story. And that's why these major controlled substance offenses are serious. Cocaine, methamphetamine, fentanyl, they rob people of their lives. And this is not amusing in any way to the court. It's sad.
They didn't say her taking drugs was amusing. They just said it was amusing the way she managed to escape from the police car. That was funny. Even I admit I chuckled at that one. I'm sure anyone would have giggled at that.
But I think the risk of non-appearance and the lengths that Miss Amy is willing to go to get the controlled substances convinced me, Ms. Perry, that a personal recognizance bond, even for inpatient at this point, would be ill-advised. Now, at some point, there is hope for Miss Amy. Recovery can be had. But the fact of the matter is that there has to be a period of time of abstinence, and sometimes abstinence has to be forced because they just can't do it on their own. So I'm going to set a bond that ensures that she's going to show up for court, because I think if I set anything lower than a bond that requires her incarceration right now, I don't think she'd show up for court. This behavior is unmistakably of a nature that she would flee. She was on abscond status from parole, provided a false name, fled the police car after she was in custody, broke into somebody's house allegedly to get away, and then in handcuffs behind her back, was able to free herself of that restraint. And it took an arrest to get her in front of the court right now. So I'm going to be setting a bond that is not a personal recognizance bond. And at this point, I'm not going to consider a personal recognizance bond, even if she did get into inpatient. That's not to say that at some point during the pendency of this case, that might not be an appropriate disposition. But right now, that's not going to happen. So on the home invasion, third degree, habitual offender, fourth offense, the life felony, bond is going to be set in the amount of $100,000 cash or surety.
Wow, $100,000. That is steep. And he knows there's no way she's going to pay that, unless she's made a lot of money from drugs. But I think he's doing her a favor, because while she's in custody, she can get the help that she needs.
You're not to use, possess, or consume any controlled substances you by a doctor if you post that bond. You are to, if you post that bond, to be fitted with a GPS monitor for your whereabouts in the event that you post that bond. On the escape, lawful custody, and malicious destruction of police or fire property, bond is set in the amount of $150,000 cash or surety with the same conditions that you not use or possess any controlled substances that are not prescribed for you by a doctor. If I didn't say it on both cases, she was subject to random testing. If she posts that bond, and on this one, likewise, she would be have to be fitted with a GPS monitor for her whereabouts. Now, I assume there's going to be a parole hold. Is that what you alluded to, Mr. Roberts?
That's what we were told by the parole department.
All right, so this all may be somewhat academic. But in case there's not a parole hold, these bonds are designed to hold you where you're at right now. I'm not going to sugarcoat it at all. I'm afraid you would not appear. So that's what we're going to do today. Both cases are set for probable cause conference and preliminary examination. Anything else for the record, Mr. Roberts?
No, thanks, John.
Or Ms. Perry?
Nothing further, thank you, Your Honor.
You're welcome.
How can you just sit in this room for hours, bro? What the?
So, what do you all think of that then? I think it's still quite funny, but hopefully she'll get the help that she needs now, and that's the main thing. So thank you all for watching. I do appreciate it. If you can like, share, and subscribe and all notifications, it helps me to get into the YouTube algorithms. I can take them off now because my ears are burning. And because I'm not monetized yet, I don't mind saying these things. People, you know, some creators want to keep their things on the private side, but I'm not monetized because I think I need like 1,500 people to subscribe to my channel. I think I've got 109 people, so I need so much more. So in the meantime, to help me to try and recover some of my costs with my monthly subscriptions to various things that I need to help to improve my channel and to make my channel grow, I've done buymeacoffee.com, and you can even put 50 cents or 50p in there to buy me a cup of coffee, and I will keep that pot going. And then if I need to update, you know, a new program, or if my antivirus runs out and that, you know, I can use that money towards it. I won't need a new computer anytime soon, because 6 weeks ago now, I was in the lucky, fortunate position to be able to buy 2 monitors, one gaming 4K one a normal one, but they're both 27-inch screens, and a 32 gigabyte Wi-Fi PC tower. And then just to double make sure on the side of it, if I ever did run out of space, I bought myself a 2 terabyte hard drive. You know, and then it's the microphone, it's the webcam and keyboard and headphones. Headphones I'm having a nightmare with at the moment. 2 pairs have got to be sent back because they just don't land up working. you know, and even this microphone is playing up. Yesterday I did just over an hour recording, and I was told later by one of my creators that I follow that there was no sound for it and the microphone had stopped working. So I had to redo that video this morning. So yeah, so I might at some stage have to invest in a better microphone, one that's not going to let me down. Right, thanks all for watching, and I'll see you on the next one. Bye.